The most common lawsuits in California relating to employment arise from misclassifying employees as independent contractors or violating FEHA, which is the Fair Employment and Housing Act. In terms of classifying employees versus independent contractors, generally speaking, AB5, which is Assembly Bill 5 in California, creates a three-part test to determine if somebody is an independent contractor. And generally speaking, if you don't pass all three parts of this test, the person is going to be considered an employee, regardless of what you thought, regardless of what that person thought they were. Under the law, generally speaking, they're going to be considered an employee, and you can get hit in the way of fines and penalties if you're not compliant with AB5. The three parts of AB5 are: one, the person has to be in a different business than your business. The second part is they have to be in an independently established business of some kind. And the third thing is they have to be free from your direction and control. You have to have all three of these things for them to actually be potentially considered an independent contractor. The vast majority of the time, the person doing the work is not in a separate line of business than the person that they're working for, which violates AB5 and makes that person an employee, or the person is not free from direction and control, or the person doesn't have their own independently established business, which means that they usually have some kind of entity that they've set up with the requisite insurance and other things that are required to be a properly established business, including something like a business license. So you want to make sure you don't set yourself up for what would be a very expensive problem by understanding that. The other most common reason for lawsuits is violation of the Fair Employment and Housing Act. This is a lot of times related to discrimination against somebody for their race, religion, their gender, because they're pregnant, because of their disability. And if they're disabled, making sure you're providing some sort of reasonable accommodation, which the law is vague on as to what constitutes reasonable, but you want to make sure that you talk to an employment lawyer so you understand what these things mean and how they apply, because trying to do this yourself is just asking for a problem. It's asking for a huge potential liability down the road that's going to be multiples of what you might have saved in attorney's fees. So do yourself a favor, get the expert advice you need. If you have questions about this, reach out to me in my office. We're happy to help you.